Good evening, everyone. Today, in this video, we are going to discuss an act which we haven't heard about before 2020. Most of us, right? In 2020, we witnessed COVID-19, a situation which we have never seen before, right? So, the name of the act is the Epidemic Diseases Act 1897. No doubt that in today's time, the names like the GST Act, IBC, Indian Penal Code, the Contract Act, right? These are the names which everyone, every law student has heard. But the name of this act, the Epidemic Diseases Act 1897, you know, this came to limelight in the year 2020 when we witnessed the situation of pandemic, right? Now see, uh, if we talk about the Epidemic Diseases Act 1897, right, it is a very short act. It has, 5 sections only, and it does not even have a definition clause. And this act was enacted during the British rule. Okay, in 1897, there was a plague in Bombay, and that is why the Epidemic Diseases Act 1897 was enacted. Now, see, I'll not say that, this act is not been invoked before 2020. If we talk about the state of Gujarat, then in 2018, the collector of Vadodara, he declared a village as cholera affected. Okay. And, in 2018, in Gujarat, during that cholera, the Epidemic Diseases Act 1897 was, invoked by the state of Gujarat, right? So many times, we have seen, some areas, some states affected by different plagues, and they have actually enacted the Epidemic Diseases Act 1897. But if we see the situation of 2020, the state governments, they had resorted to this act to deal with COVID-19, right? Now see, this is a 123-year-old legislation, right? Containing just 5 sections. So if we talk about 2020, 2021, 2022, then there is a need of comprehensive public health act, right? We cannot be dependent upon this old act like the Epidemic Act 1897, right? It is non-functional in itself, right? Because with the advent of uh, infectious diseases, widespread global movement, the legal framework need to be strengthened under sound public health law infrastructures, right? Today, in today's time, we need isolation facilities, quarantine, right? Travel or movement restrictions are there. Compulsory vaccination things are there. So the act, this 1897 act, does not provide these things, right? And see, uh, there were some arguments saying about that this act should be repealed or it should be substituted by a better act, right? So in 2020, there was an amendment in the Epidemic Diseases Act 1897, and now it is called the Epidemic Diseases Amendment Act 2020. So in today's video, we are going to discuss both the acts 1897 as well as the Amendment Act of 2020. Moving on to my next slide, as I said that in 2022, in 2020, the need of the hour is to look at the present scenario and the medical conditions that we need. In the previous videos, we have already seen that right to health is a fundamental right that is being guaranteed by the Constitution of India through various judicial precedents, right? So what happens, uh, there was a public interest litigation filed, and the name is Dr. Gerald Bennett versus Union of India. So basically, this public interest litigation, it sought availability of personal protective equipments for medical professionals, and it highlighted the plight of doctors and nurses due to incidents of violence, right? Because when this pandemic happened, we have seen that the doctors, the nurses, the healthcare personals, they faced a lot of violence by the patients, the maybe by the relatives of the patients, So there was a need of the hour to protect the doctors, nurses, and the healthcare personals. So basically, this Dr. Gerald Bennett versus Union of India, it was a public interest litigation that was filed to invoke something, to give further protection to the healthcare personals, doctors, and nurses who are providing day-to-day services. Every hour they were providing services to the common people. All right. Now see, in the Epidemic Diseases Act of 1897, the Amendment Act of 2020 has made several amendments. See, there was no definition clause in the previous act, but by the 2020 Amendment Act, you know, a definition clause has been inserted. See, Section 1A provides that in clause A, act of violence, right? The definition of act of violence, it means, you know, what is an act of violence? Now, see, act of violence means any act that is committed by a person against a healthcare service personnel serving during an epidemic. So, as I said that, this Amendment Act of 2020 is giving protection to healthcare personnel, healthcare service personnel, which was lacking in the Act of 1897. So the definition clause has started with, defining what is an act of violence. So please remember that, if I'll tell you the name of the acts, if these acts are committed by any person against a healthcare service personnel who is serving during an epidemic, right? For example, harassment, right? And harassment that impacts the living or working condition of healthcare service personnel, and harassment which is preventing healthcare service personnel from discharging his duties, right? That is an act of violence. Okay, any kind of harm, injury, hurt, intimidation, or danger to the life of healthcare service personnel, right? Either in the clinical establishment or any other place where this healthcare service personnel is serving the patients, right? Is under working conditions. So if any person causes him harm, injury, hurt, intimidation, or dangers to his life, then it will be considered an act of violence. All right. If anyone causes any kind of obstruction or hindrance to healthcare service personnel who is discharging his duties, right, that is also an act of violence. If any person causes any kind of loss or damage to any property, right, or any documents in the custody of, healthcare service personnel, then that is also an act of violence. So, uh, Section 1A, Clause A talks about act of violence. All right. Now see, Clause B talks about healthcare service personnel. Who is a healthcare service personnel? So, see, a healthcare service personnel is a person who carries out his duties, right? When there is an epidemic, and the responsibilities that are related to, such healthcare service personnel to overcome the epidemic, right? He will come in direct contact with patients who are affected by the epidemic, right? And that is why he is at the risk of being impacted by such disease and epidemic. So healthcare service personnel also means, and it includes any public and clinical healthcare provider. For example, nurse, paramedical worker, doctor, community health worker, right? And any other person who is empowered under this act to take measures to prevent the epidemic or spread of the disease. So we call them healthcare service personnel, right? And also a healthcare service personnel will be a person who will be declared by the state government by any official gazette, right? By notifying in the official gazette that such and such person is a healthcare service personnel. So this person will be included under Section 1A Clause B. All right. Now, another important definition under Section 1A is property, right? So, see, property means, a clinical establishment, right? And clinical establishment is defined in the Clinical Establishment Registration and Regulations Act of 2010. Property also, includes any facility that, is identified for quarantine purposes, isolation purposes, for patients who are, you know uh, quarantined and isolated during an epidemic. So property will include that premise also, or any mobile medical unit, right, or any other property in which a healthcare service personnel has direct interest, right, in relation to the epidemic. So that will be included in the definition of property. Now moving ahead, now see, if we talk about the previous act, right, as you can see in the next slide, yes, see section 2. Now see, if we talk about the previous act, then section 2 provides, for special measures, and it prescribes regulations related to dangerous diseases, right, epidemic diseases. So what happens, right, in the previous act, if any state government, right, if the state government is satisfied that, the state or any part of the state, it is threatened by, any dangerous epidemic disease, or there is an outbreak of any epidemic diseases, right, then the state government, it may take or it may empower any person, to take measures, or temporary regulations that will be observed by the public, right, or any person or class of persons, as will be deemed necessary by the state government, so as to prevent the outbreak of such disease, right, and it is not spreaded elsewhere. So basically, to control the epidemic or any, dangerous epidemic disease, the state government, if it is satisfied, then it will take any measures that it deems necessary, right, or it can empower or direct any person to take such measures, right, to provide or to prevent, necessary means, so as to curtail the spread of epidemic diseases, right. Now see, in section 2 of the previous act, this power has been given to the central government also, right. So if the central government is satisfied that, India is threatened or visited by an outbreak of any dangerous epidemic disease, right, then the central government may take measures and it may prescribe for regulations, right, to control the spread of this disease. In fact, in the previous act, if the central government is satisfied that, any ship or any vessel that is leaving any port, right, in India, or arriving at any port of India, and they think that, there can be an outbreak of any dangerous epidemic disease through that ship or vessel, right, then they also, the central government has a power to detain that ship or vessel. All right. Now see, if we talk about the Epidemic Act 2020, right, the amendment. See, the amendment of 2020 has invoked section 2B also, right, in the previous act. And section 2B provides that, no person shall indulge in any act of violence against a healthcare service personnel, or cause any damage or loss to any property during an epidemic. So basically, this was missing in the 1897 Act. But the Amendment Act has included that, there will be prohibition of violence against healthcare service personnel, right? And there will not be any damage or loss to any property during the time of pandemic, because this will be considered as an offense. So we will also discuss in the coming slides the penalties that will be imposed if any of these sections are violated. Now see, let's come to the penalty part, right? See, if we talk about the previous act of 1897, then section 3 provided any person, will disobey any regulation under 1897 Act, then, they will be punished under section 188 of the Indian Penal Code, right? But if we talk about the present Amendment Act, then see, many things have been included. So section, you know, section 3, uh, it has, we can say, broadened the penalty provisions, right? So if you cause, right, if anyone causes an act of violence, okay, or abets the commission of an act of violence against a healthcare personnel, right, or if you cause any kind of damage or loss to any property, or even if there is an abatement to cause damage or loss to any property, then that person shall be, punished with imprisonment for a term which shall not be less than 3 months, and it may also extend to 5 years, right? And also fine will be imposed that will not be less than 50,000 rupees, but which may extend to 2 lakh rupees, right? So if you cause, or if any person cause any kind of an act of violence against a healthcare service personnel, right, or abets or causes loss or damage to property or its abatement, then this punishment will be imposed, right? Now see, also the Amendment Act provides that if, you know during the commission of an act of violence against a healthcare service personnel, if under section 320 of the Indian Penal Code, grievous hurt is caused to such healthcare service personnel, right, then there will be an imprisonment for a term which shall not be less than 6 months, but it may also extend to 7 years. Please remember the fine, right? There will be imprisonment for a term which will not be less than 6 months, but it can extend to 7 years, and fine will be imposed which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. So in case of grievous hurt, it is very simple that imprisonment of minimum 6 months to 7 years will be provided to you, right? And fine that will be imposed will be 1 lakh to 5 lakh rupees. All right. Okay. Now see, please remember that, the Amendment Act of 2020 has also, you know, uh, made these offenses, cognizable and non-bailable. And any case that will be registered under section 3 of this act, it will be investigated by a police officer who will not be below the rank of an inspector. All right. And please remember one another important point, that is investigation in these cases, it shall be take place as expeditiously as possible, right? The proceedings and all. And the investigation, please remember that it will be completed within a period of 30 days, okay, from the date of registration of the FIR. And of course, if we talk about the proceedings, then they shall be held as expeditiously as possible, right? And when the examination of witnesses has once begun, it will be continued from day to day until all the witnesses have been examined, right? So the court will make sure that the inquiry or trial is concluded within a period of 1 year, right? And if it is not concluded within the period of 1 year, then the judge shall record the reasons for not completing it within the period of 1 year. And remember that uh, the set period can be extended further, but it will not exceed more than 6 months. Okay. Now see, section 3B under the Amendment Act, it talks about composition of certain offenses, right? So the act says that uh, if a person who is prosecuted for committing an offense under section 3 subsection 2, then if the with the permission of the court, this offense can be compounded by the person against whom such act of violence is committed. So basically under section 3 subsection 2, there can be composition of offenses, right? Now the Amendment Act has also talked about presumption as to certain offenses. So basically section 3 clause C talks about presumption, And whenever a person is prosecuted for committing an offense under section 3 subsection 3, then the court shall presume that such person has committed such offense. That means there will be presumption until and unless contrary is proved. Okay, so we have broadened and expanded this previous act of 1897 through various amendments in 2020. Now another important presumption that is provided by the amendment act is presumption of culpable mental state under section 3 clause d, right? So what happens that under section 3 clause 3, if there is any prosecution for an offense, it requires culpable mental state on the part of the accused, right? And the court will presume the existence of this mental state. But please remember, this is a defense for the accused, that to prove the fact that he had no mental state with respect to the charge that has been, you know he has been accused of that charge. So this is also a presumption as to certain offenses which require mental state, culpable mental state. All right. And culpable mental state, we all know that it means, it includes motive, knowledge of fact, belief, intention, reason to believe a fact. Now see, another important section is section 3E, that is compensation for acts of violence. So see, this section 3 clause E provides that in addition to punishment for offenses under section 3 subsection 2 and subsection 3, the person who is convicted, he shall also be liable to pay by way of compensation an amount which will be determined by the court, right, for causing hurt or grievous hurt to any healthcare service personnel, right? And if there is any failure to pay such compensation, then that amount shall be recovered as an arrear of land revenue under the Revenue Recovery Act of 1890. Okay, so these are some of the important sections that has been inserted in the 1897 Act by way of amendment in 2020. So I have covered almost all the sections that are important. So thank you so much.